Good morning, Your Honor, or afternoon. Jennifer Joslin for Mr. Feltz. He is here via Zoom. I also see Ms. Feltz present via Zoom.
All right. So this one is just a little bit confusing, and this one it's on for adequate cause.
Yes, Your Honor. It's on for adequate cause in temporary family law orders. When we were here last time, we had overlooked that there was a mediation provision prior to coming to court. So we took the matter off docket. The parties went to mediation, did not reach a resolution. So we are back on my client's motion to modify the parenting plan and motion for adequate cause.
All right. I didn't really get any feeling when I read through this that Mrs. Feltz, are you objecting to the court looking into and possibly modifying the parenting plan?
Yes, I am. And I guess I apologize, by the way. I'm not super familiar with this. I'm obviously not a lawyer, but I am representing myself.
Mm-hmm.
The reason that I am disagreeing with it too, as I'm not sure how much you read over or how familiar it was, but this entire case was in regard to transportation. And I guess my biggest thing is I wanted to, before we got into this or before, there was any discussion on it, the other party was requesting that we change the parenting plan in regard to fairness of transportation. And the reason that I disagree with that is, long story short, I have our daughters Sunday through Friday every single week. We have been divorced since 2019. I have had them almost full time the entire time. I am a single mom that works full time. Those two girls are my priority. I pay for everything for them. I do doctor's appointments, dentist appointments, all of their education. I pay for their health insurance, cell phones, do all the day-to-day stuff. And then if I need help, I don't have the family support out here that the opposing party has. My family lives in a different state. And so, in all fairness, I know that I am the custodial parent out of both of us, but with all due respect, I do not believe that, that pertains to him giving up his parental duties. That should be equal. And so when it comes to this transportation issue, we have continuously argued regarding Fridays at school pickup. I have asked him to pick up the girls from school on Friday. I have agreed with him to meet on Sunday evenings. There's been a large issue with me moving out of Ridgefield and moving a little further south, which, long story short, I had to do as I lived in a rental for 4 years, and the owner of the rental property took it off the market, and I had 60 days to find somewhere to live. And the girl's father chose to move 50 plus miles north, and we have argued continuously about this drive. And so we just have gone back and forth, and it's not just about the transportation issue, but it's about, about parenting as a whole. I take care of everything.
Well, hold on just a second. What the decision today is whether or not we're going to make any modifications at all to your plan. That's what it's here for today, not all the details about what may or may not get changed. It's really an issue of, is there a reason to make a change to your plan?
Yes. And Your Honor, I would object, as this is our motion. We haven't had a chance, and I think Your Honor was just asking yes or no if she agrees, not getting into the meat of it. Since this is my client's motion, he would like to be heard on the issue.
I guess I'm trying to understand what issues are actually being requested. So
yes, Your Honor, the issues before the court that are Yes, transportation and a change to the parenting plan that reflects what they've been doing for the last 2 years. So he's not asking for a major change. It's a minor change, and it's only the parenting plan and the transportation.
So I guess I'm confused. It looked like there was a lot of changes being requested in the parenting plan when I read through it.
The only changes were in terms of section 8 is reflecting what they've currently been doing, which is the Friday to Monday and then Friday to Tuesday in the summer. And then it was the transportation to halfway because mom has relocated without proper notice. And it was adding a holiday schedule because my client would like mom to actually utilize some of the holidays because they didn't have a prior schedule. That's really the only changes that are being asked to be made.
You added about 15 paragraphs under section 14, which are not in the original plan.
Yes. We added the typical standard, no derogatory comments and things of that nature.
Yeah. Cancel, those aren't standard language. They're not part of the standard forms. Those are optional language. So, and they're not in the original parenting plan. So
yes, that's just based on some of the actions of opposing party. Some of those we need to have included. And, things such as no negative comments, not talking to the children should be something that's in there. But the meat of it is the transportation and the reflecting what they've been doing for their parenting plan.
We have not followed our parenting plan that was written when we got divorced for years. We have not followed that plan at all. So I guess the biggest thing would be just having an adjusted, written out plan that is court ordered, that is going to benefit the girls the most and create consistency for them for who would be picking them up and dropping them off.
Okay, so let me understand. So the parenting plan that was issued back in 2019, you have not been really following that parenting plan, is that right?
Correct.
They have not.
We have not followed that.
Okay.
For the last 2 years is what we've been put in my client's declaration, is what they've been doing. My client simply wants that reflected. Opposing party doesn't want to put that on paper.
That I object. I will put something on paper, but we have not followed that plan for the last 2 years.
I think the confusion is she doesn't under Miss Phelps. I think the confusion is that we want to put what they're actually doing, and Miss Phelps will not agree to put what they're actually doing, which they've been doing for the last 2 years in the parenting plan. I'm happy to go over it. My client would like to be heard.
Hold on a second. One person talk at a time, please. And I'll be happy to hear everybody, but I can only have one of you talk at a time because it doesn't come through clearly.
My client would like to be heard, Your Honor. So if you want, I can address the adequate cause and what my client is seeking. And I think that would better help the court to understand why he's seeking the transportation he's seeking.
The issue of adequate cause, if you haven't been filing the parenting plan that was entered back in 19 and you're doing something completely different, that would be grounds in and of itself to get a parenting plan adjusted to match up with what you're doing, assuming that that's what you both want. In the petition, I was just trying to find here, looking at the 19. So if you both agree you haven't been doing the 19 plan, then there's grounds to take a look at it. That doesn't mean that either one of your proposed is the way the court would go at this point. So, because I've got two proposed parenting plans and they're different. So I can make a finding of adequate cause. I don't have a problem with that. I think based on what we have here, to take a look at the plan to figure out what it needs to be. And when I looked at the two proposed, they're in different formats, so it's kind of challenging to compare them.
I think and I don't want to speak on behalf of Waylon, but per our conversations outside of this, I mean, I have no problem, and I agree that we need an updated parenting plan that is in writing. I think it would be super beneficial for the children, and also, like I said before, just to have something that is consistent for both of them. Like I said, we have not been following that. I currently have them now Sunday through Friday. And then he is supposed to pick them up from school on Friday, which that is a big issue we were hoping to figure out today. And then in the summer previously, I would have them Monday through Friday. And so he just kept them one extra day. As far as the holidays go, what was written in the declaration, I disagree with. I have always just, like I stated before, I don't have that family out here like he does. And so I've always done what's best for the girls, in the sense that, you know, when these big holidays come, such as Christmas and whatnot, I want them to be with people they're familiar with. And that's also what they have wanted. So I have willingly sacrificed having them on holidays so that they are able to be with ones that they're comfortable with and that they know, just in the sense to create the most stability and the most sense of normalcy since we have separated. And as far as holidays go, I'm fine with rotating back and forth or whatever we need to do for that. My biggest concern is the girls. They're both old enough to voice their own opinion. And so I have always done with what works best for both of them.
And Your Honor, regarding the parenting plan, it doesn't sound like Mom is disagreeing with what my client has stated, that he has Friday to Sunday and Friday to Monday in the summer. It is not after school. It's been 5 p.m. If you look at the prior parenting plan, I believe the exchange was like either 6:30 or 8. And so my client's just seeking to establish the Friday to Sunday and Friday to Monday. And Ms. Phelps isn't disagreeing that that's what they've been doing. So I guess my client's frustrated and doesn't understand the issue and why it is taking so long to just simply put that on paper. In regards to the holidays, if Ms. Phelps doesn't want them, you know, my client will take them for all of the holidays. My client's point of view isn't that she is the martyr and saying have them. It's more that she wants her time to do whatever. But if that's the big issue and she wants my client to have all the holidays, he'll take all the holidays. And we can do it that way. I think the biggest issue that we have besides that parenting plan really comes down to this transportation, which originally it was, you know, picking up parent, dropping off parent. When this parenting plan was made, my client lived in Cowlitz and they agreed to do the pickups at at the residences. And then my client did move to Toledo, but what happened is we had November 2019, Mom moved to Ridgefield without filing a notice of intent to relocate and without asking my client and getting his permission, thus putting this large distance between them, not something that went before the court, not something they agreed to. In September 2023, she moved again without filing a notice of intent to relocate, and without his permission, she moved to Camas. She just recently moved again in April out to Hawkinson, again without filing a notice of intent to relocate and without my client's permission. So Mom is habitually moving without getting my client's consent, without filing a notice, without doing the proper channels, and basically just says, forget you, Waylon, you got to deal with it. And then she demands my client come and pick up not only earlier on Fridays, but from the school. All my client's asking is for a fair halfway point because Mom keeps going. You know, additionally, we had offered that we can continue to do one parent pickup, one parent drop off. Ms. Phelps doesn't want to do that, but Ms. Phelps shouldn't be rewarded by not following court orders. By all she wants to do is have my client do the entire long drive, and then she'll only meet halfway on the Sundays or Mondays. That's not fair to my client or to the children. And so it's the proposal he has is a fair halfway point, and having something that's there in writing as a halfway point is going to be best. So then there's not this control where she says, come to the school, come to my house, come here, and where she just moves and moves and moves. And he has to just kind of go wherever she goes.
I object, and I also disagree with all of that. I moved in 2019 out of Kalama to Ridgefield.
Okay, well, let me stop you both for a minute. Okay, I'm going to find adequate cause to modify the parenting plan. I'm not going to modify the parenting plan today because we're probably going to have to set a hearing on that, it sounds like. So I'll enter an order of adequate cause today.
We did send Your Honor proposed orders, but we also cited it on today for a hearing for the motion for temporary family law orders.
Right, and I saw that. I'm not inclined to adopt a parenting plan today, but I can. And the only thing else that was in there was that family wizard piece, I think, and that sounded like it was agreed to.
The Friday.
Yeah, my client's in.
I do not agree.
My client is in agreement.
Piece.
Okay, go ahead, now. I couldn't hear that.
Oh, I do not agree to the Friday piece, and that information that was just given was completely incorrect as well.
Your Honor, she just agreed that she moved in 2019, so everything I've said is correct. She didn't deny that she moved. She did move.
Counsel, I'm entering adequate cause. I'm not making a change in the parenting plan today. It sounds like we probably need to set a hearing and flesh this out a bit.
Yes.
So
and apologies. We did set that for today, Your Honor, on our citation.
Set what for today?
The motion for temporary family law orders to change the
I
parenting
understand
plan.
that. I'm not inclined to make a change in the parenting plan today.
Okay.
Sounds like we need more information. We may need a guardian ad litem at this point. It sounds like, but I'm entering the adequate cause, which I thought I had here. Just a minute. All right, so I'm signing the order that permits the adequate cause to move forward. And then I guess the request for temporary orders, it sounds like is that there's quite a bit of difference in the one thing that appeared to be agreed to was this family wizard piece, which is under your temporary order, section 8. And the problem is I'm not inclined to sign either of these parenting plans because I can't really tell all the differences between them. Like I said, section 14 adds a whole bunch of stuff that I haven't heard any grounds for adding other than the family wizard piece.
So are we going to set this over to another docket or another date, Your Honor?
Well, normally we would go through a settlement conference type process. If you don't think you need a guardian ad litem, which I don't know if you do or not.
I don't think a guardian ad litem is necessary to confirm a parenting plan and transportation. Unfortunately, I don't think settlement conference would be of assistance as they've already tried mediation.
Well, there's also, we have to deal with the child support issue, it looks like, because that was raised in her response. And I don't have any information on that, I don't think.
No, there's been no motion for child support.
Well, it's as far as the case itself goes, because that's part of the request under the response. So we'll probably need to get some information on both sides about that before we can address that. So I guess my question is, based on the notes that I said, right now you're doing Sunday to Fridays?
Yes.
Friday to Sunday.
Friday to Sunday.
Yeah, Mr. Phelps Friday to Sunday night, Miss Phelps Sunday night to Friday night.
Was that correct, ma'am?
Yes, correct. I
Okay.
do Sunday at 7:30 to Friday.
And that's at the same time?
No, the time differs depending on when the opposing party is off of work and it is convenient for him.
That is not actually correct. The agreement was always 5 or 6:30. She's deciding to change it. I think if we can just pick a time, 5, 6:30, 7:30, that's fine. We just need a time.
I will do 3 o'clock on Fridays if it's temporary.
Your Honor, it should just be the same as their prior, especially with her moving in the distance. If she's going to require my client to come at 3, which has never been an agreement and nothing that they've done, he's going to consistently miss work every Friday. So they've always done an evening pickup. It's in their final parenting plan. It was either 6:30 or 8:30. They always anticipated that. It should remain the same. So we can do 5 to 5, we can do 7 to 7, we can do 7 to 7:30. But what Ms. Phelps wants is not having to have any responsibility on Friday. And that's where she requests my client to just come to the school. They just need something that's reflective of what they've been doing and what the parties intended. And their prior parenting plan shows an evening pickup.
However, I disagree because we have never followed that. So it does not matter because we have never followed that. Also, I also work full time and I miss work multiple times a week to get my children on early release days or pick them up for dentist appointments or doctor's appointments. But that is part of parenting, with all due respect. And all Waylon is asked to do is to pick the children up from school 1 day a week, which he is already in Ridgefield, Washington, because he works in Ridgefield, Washington. And my children also do not go to school in Camas. They go in East Vancouver in the Evergreen School District. He's already close to them anyways, and I do the driving 4 times a day, 2 different times a day, an hour apart, bringing the children to and from school.
Your Honor, that's her responsibility. She decided to move out of that Evergreen School District to Camas. So her saying, I do all this driving, that was her decision to move and leave the children there.
Okay, how about if we just do this? We have 6 o'clock on Friday, 6 o'clock Sunday, each party pickup.
Picking up parent, Your Honor?
I'm sorry?
Is it picking up parent?
Is what picking parent?
Like Friday, he would pick up, Sunday she picks up if we're not doing the halfway.
Correct.
Okay.
So
my client is in agreement.
I am not. So that would mean, Your Honor,
I'm going to have you each pick up at the beginning of your time. I'm not doing a whole lot of stuff on this. I'm just trying to get down on paper what you're going to do in the temporary. And then we'll need to be coming back because I'm going to need to get more information about finances as far as the child support, as far as the holidays, whether or not there's any of these other provisions in 14 are appropriate or necessary.
Your Honor, that means on Sundays, I have to drive 2 hours, 72 miles north and 72 miles back to pick up my children.
Same with my client.
And on Fridays, Waylon drives to Ridgefield to go to work. He is already less than 20 miles from the children's school. And today is the children's last day of school. So if he is picking them up from my house in Hawkinson, it is about 12 miles from him. So I will be driving 2 hours on Sunday evenings to pick up my children every single Sunday. And he is still not driving. And I do everything for those girls. He has asked nothing of them except for to pick them up.
I'm making a temporary decision. This may not be the final decision. I'm making it based on the information I have in front of me right now. So if you want to send up a new parenting plan that has just those changes, adding, it looks like, I think you have it as number 1 on your section 14 on the wizard plan.
Okay.
And then no other changes to the plan until we have further hearings. And then, like I said, we're going to need, we'll need to get financial declarations for both parties to address the child support.
Thank you. I think I can send that to you as soon as we're off, Your Honor. And I think regarding the rest, you know, if Ms. Phelps wants to move forward on the child support, you know, certainly cite it on and serve us, and we can do the financial information.
But we'll deal with it before we're done with the case because it's part of the response,
Yes.
one of the issues before the court. So there won't be a final parenting plan until we address that.
Understood, Your Honor. Do you need me to revise a temporary order
Well,
as well, Your Honor?
I'm just crossing out the temporary parenting plan language and leaving the balance of it.
Okay. I will, as soon as we're off, Your Honor, I'll get that to you and your JA and copy Ms. Phelps. If just give me a few minutes.
Well, we'll probably, do you want to set a presentation on it?
I don't think we need one if I'm just sending it to Your Honor that reflects what you've made a ruling upon. I think if we can just send it in, we're never going to get an agreement from Ms. Phelps. So I'd rather not delay it. I'd rather just send it in.
I'm going to be on my docket for a while, and I'm sure we'll get it entered today. You can send it and we'll take a look at it.
Okay. No, I understand, Your Honor. You're quite busy. Even if it gets entered sometime this week, it's fine.
Okay.
Thank you, Your Honor.
You're welcome. Get to my notes here. Okay. So this is on for two things today. One was a show cause on the contempt motion, and then one has to do with an adjustment for child support. And I did have a chance to review through documents that were filed. And this one, give me just a second. This is an ongoing case, I believe, because I see Mr. Lawrence still involved in this matter?
He is the guardian ad litem. He was just appointed and is working on his investigation.
Got it. Okay. That's right. Okay. So at this point, let's deal with the contempt issue first. And then I can talk about the child support issue.
All right, the contempt was Ms. Boaglio's motion, so.
Okay, and I did review that motion, and I did review the response to it. Ms. Boaglio, anything you'd like to say about that at this time?
Yes, I brought the matter up because I feel that that Jonathan is hiding some of his income and that he has a lot of family support at this point from his wife. And he's been either unemployed or underemployed for at least 2 years now, leaving the full financial responsibility on me for Calum. And I've been on food benefits, and I learned just recently that I should have had the state pursuing child support because of that. So that was just my lack of knowledge about that part of the law. But I'm just wanting for him to present his full financial background. He's asking for a deviation, which, to the best of my understanding, that means he needs to report income from his spouse, including gifts and real estate. And there's just a lot that I feel he's kind of withholding. And I just would like a fair judgment to be made about that.
Right. Initially, your motion was to find contempt for not paying under the, I believe, under the temporary order. Do you want to talk about that?
So I reviewed his financial disclosure. Oh, I'm sorry, about the previous not paying. Yes. So he requested from me on several occasions to reduce child support. And I went back and reviewed, and he's really only paid the full support amount, I think 6 months total out of the entire time that we had that agreement. And I had allowed that just because he always has a very good reason, or appears to. But I feel like he took advantage of my kindness, and I feel that he has other income he's chosen to hide, and ever since he got married, it seems like he just doesn't care to have a job that really provides much income, even though he has the ability to do that. So that's where I felt that was to show that he did that willfully. And I know that he's very skilled. If he used to work in Vancouver, and he's a very skilled worker, that he can make quite a bit more than DoorDash. So I feel it seems to me like he's trying to represent to the court as having less money than he is, which to me seemed fair to say that that was contempt and willful.
Okay, thank you. Ms. Powers?
Thank you, Your Honor. I will address contempt first. In order for the court to find Mr. Walker in contempt, the court must find that his failure to pay child support was willful and intentional. The current child support order was entered in January 2021 and requires Mr. Walker to pay $748 a month. We provided documentation to the court showing text messages between the parties, where the parties made 3 different agreements about child support, agreeing that Mr. Walker would pay less amounts. This began in October of 2021. They initially agreed that Mr. Walker would pay $350 a month. He ended up paying $385 a month, and he did this from October 2021 through March 2023. In March 2023, the parties, in April of 2023, the parties reached a new agreement where Mr. Walker would pay $200 a month in child support, and he's done that. He's paid the $385, and then he paid the $200 a month, and he did that based on the agreement of the parties, and that agreement was memorialized by text messages that have been filed with the court. Because Mr. Walker was following the agreements that the parties made together, the court should deny the contempt and not find him in contempt, because he did follow through with the agreement of the parties. In terms of daycare, my client sent information to the court that he objected to some of the preschool. It seems to be a disagreement between the parties about whether or not Caleb had to have been put back into daycare in January of 2024. For that reason, we're asking that the court deny contempt for the daycare payments, or if the court grants contempt on daycare, we'd ask the court to reserve a judgment until finalization on this matter so that more information can be presented to determine the correct judgment amount. With the court,
Your Honor,
Oh, ma'am, let her finish and then we'll come back. I'm hearing you both, but I can only hear one at a time.
Okay, so just to summarize for the contempt, we do not believe Mr. Walker's in contempt. The parties negotiated an agreement together. Mr. Walker relied on that agreement and fulfilled that agreement in good faith. Ms. Boaglio had mentioned that a payment had been missed in January of 2024. My client went ahead and made that payment today, so he has paid in full all of the reduced payments that the parties had agreed on. It's clear that Ms. Boaglio no longer agrees with the agreements that they've made, so we're asking the court to adjust child support today so that there is a clear order going forward to base on in the future. So that's our response in regards to child support, I apologize, in response to the contempt.
In just a second here. Okay, Mrs. Boaglio, go ahead.
Yeah, so Amy had stated that I was in agreement. I did come to agreement with Jonathan, when his children were born, or his twins were born in April, and then I realized that he wasn't planning to get a job. I realized that that was just kind of how he wanted to do life from that point forward, and that he thought that would just be the agreement forever. That wasn't the way that I took it, when I made the agreement, I said that I was understanding of his situation at the time. But once it came to be a year of him being unemployed or very underemployed, I realized he wasn't planning to change anything. In June, actually, is when I told him that I was no longer in agreement. I did share a text message with the court to show that I stated to him that, so I have not been in agreement with this since June of 2023, because I realized I was being taken advantage of. And I realized that his best interest isn't about what's best for Caleb. It's about really what's best for him.
Did you convey to him in June of 23 that you were no longer agreeable to that?
Yes, I said I wanted to have the state's help in determining child support moving forward, because the state does look at things like underemployment and unemployment as being ways that people try to get out of paying their support and getting out of their parental duties.
Okay. All right. Well, I guess the problem I have on the contempt on this one with regards to the child support payment, it sounds like there has been some, and again, looking at the documents that were filed, there's been some agreements back and forth. And as long as he's abiding by those agreements, which were memorialized at some level, I'm not going to find him in contempt under those. I am concerned in the daycare issue because that's pretty clearly set out in the child support order at I think it's 74%, if I'm reading that correctly.
Yeah, and also Caleb has gone to that childcare since he was a year old. The only reason that he decided he didn't want him to go there is that Caleb no longer gets a subsidy, and also I was an employee at that school for a period of time where I got a 50% discount. So I've always paid the entire amount for the childcare because I've made so many accommodations for Jonathan over the years.
Let me stop you and say, have you provided him any bills for the daycare?
Yes, and also he has access to that through the school too, because he's listed as a contact, so he should be receiving them from the school, I would believe.
My question is this: did you send a bill to him that says, "Here's the daycare bill, you need to pay this"?
I did by text message, yeah, and I shared that with the court also. And I also filed it with the court when, I think it was in January, maybe.
All right. So, I mean, it seems to me that that's pretty clear in the order, and that wasn't necessarily part of the agreement to decrease the child support amount. So it seems to me that probably is contempt. I will defer on setting a judgment of that. I'll give counsel and Ms. Blagley an opportunity to go through and look at what the record shows and make sure the interest is calculated correctly, and then grant a judgment later in the case.
Your Honor, are you reserving on the judgment as something we will present later, or is that something you want information on before we present the order on contempt?
I think we can present it later. I don't think we need that right this minute, because we've got the other question I've got, which has to do with the other part of this, which is the motion for child support. I probably need some more information on that before we're going to be able to address that. When I looked at the declaration, financial declaration, let me see here just a second, that was filed.
Oh, my client's financial declaration was filed June 11th. We also filed his wage stubs with DoorDash on May 30th. And then he had previously filed his 2022 tax returns and his previous pay stubs from his last job, Lowe's, on September 8th, 2023.
Right. What I had though was his declaration, which he filed, indicated expenses of where did that go here? Like $6,700 a month, is zero income, which is that doesn't work.
Well, he did indicate in his declaration that his wife's family has been lending them money. So that is what has been making up the difference. His wife is unemployed they do receive some child support for the other 3 children.
So we're bringing in $6,700 a month because that's what he put down his declaration as far as his expenses.
Okay.
That's my, I mean, so he's paying it somehow. I assume, if that's what his expenses are. That was the one filed 6/11, 6735 expenses and 0 income.
And that would be consistent with the one he filed also in, I believe it was in either October or November of 23, which I did not agree to because I noticed the same.
I'm not sure how I can square that. If he's paying out $6,700 a month, that would be his income, unless there's some other documentation showing something different.
Well, he's paying it out with loans from the family, and then we did indicate he is receiving food stamps and WIC, so that's covering the cost of the groceries.
So just a minute here.
That would be an awful large amount of loans to repay with a job that makes that wage, and I don't see him making any motion towards changing his job situation. So I find that hard to believe that that would be a loan and that her family would be willing to continue to loan that unless it's just a monetary gift.
And I guess my argument would be whether it's a gift or a loan. My client has indicated it is a loan. Either way, it's not a regular income, and child support needs to be based on the income. My client admits that he is underemployed. His wife is in a medical situation right now. They have 1-year-old twins. They're expecting another set of twins. She's had a lot of health issues, and as a result, he's been unable to work a traditional job since midway through the pregnancy with these first set of twins. So it is a situation where the family has been stepping in and helping, but I would assert it's not appropriate to include that as part of his income for purposes of child support.
Except that he's requesting a deviation. So in that case, he does have to.
Ma'am, if you can just wait until she's finished talking before you start talking, please.
It is clear that my client is in a dire financial situation. And that's part of why it's important that child support be adjusted. And Ms. Boaglio understood that historically, which played into her kindness in agreeing to lower the child support amount. He's disclosed what his real income is, and you're right, his expenses far exceed that. But it doesn't mean that there's additional income there that should be included with the child support calculation.
All right, ma'am, if you wanted to go ahead, you were about to say something. I just need to have you talk one at a time so I can hear what you have to say. Go ahead.
Sorry about that. I was just pointing out that the differences, I think typically maybe he wouldn't need to report that income, except the fact that he is requesting a deviation, which is a special exception from the court to say he doesn't have to pay as much as someone normally should be required to pay under these circumstances, and to make up for his being underemployed. When you request a deviation, from my understanding, you do need to start to report spouse's income, gifts, and things like this, because that's what's allowing him to get a job that makes $1,000 a month and have that much money in expenses. He's very comfortable, and that shouldn't come as a negative to Caleb. I just want to make sure that Caleb's needs are being considered in this and not just the needs of Jonathan.
May I reply, Your Honor?
Sure.
Thank you, Your Honor. When we're looking at Mr. Walker's income, the starting place, of course, is where his income was when this final child support order was entered. At that time period, Mr. Walker was working significant overtime, 10 to 16-hour days, and that job grossed about $5,000 a month, netted about $4,000 a month. That job ended in November 2021. That was before any of the additional kids came into the picture. Mr. Walker has not been able to get a job at that wage since, and he explained to the court in his declaration he's never been a high wage earner. The reason his income was as high as it was during that time period was because of the significant overtime. After losing that job and having that job end in November 2021, Mr. Walker went on to work for a nail salon, and that business closed 5 months after he started there. So then he was able to get a full-time job at Lowe's. We believe that his full-time employment at Lowe's reflects accurately what he'd be capable of working in a full-time position. So we're asking the court to impute him at that wage of $16.50 an hour, 35 hours per week. That was his last full-time income. It's been about 3 years since he worked at that higher wage with the significant overtime. We are asking for a whole family deviation. That's because Mr. Walker does have 3 more legal children in his home. He has disclosed to the court that he receives gifts. He's disclosed his tax return for 2022. He's disclosed his income. We're agreeing that at the moment he is underemployed, and that's why we're asking the court to impute him at the $16.50 an hour, 35 hours per week. But Mr. Walker is responsible for all of these children, and we believe it's appropriate that the court does grant a whole family deviation. Currently, he has 3 additional legal children. He also has 3 additional stepchildren. We're not seeking a deviation for the 3 stepchildren, only for his 3 legal children. And then he has another set of twins that are due this summer. We would ask beginning in September that he receive a whole family deviation for all 5 kids. That's his 2 sets of twins plus a 7-year-old Liam. And then prior to September that he have a whole family deviation for the 3 children.
Well, like I said, I think I need to have all income that they have in the household before I can grant the deviation. I'm happy to look at that. He very well may qualify for it, but I think it's required to disclose that.
So in terms of disclosing that, I guess, what is the court looking for a declaration talking about the amount of gifts that he's receiving? Because we have disclosed the income and tax return.
No, just a minute, because I didn't see a tax return.
That was filed September 8th. My client had filed a motion to adjust child support back in September, but had not understood to docket that motion.
Well, do we have a current tax return? I assume they filed for 2023.
We could file that.
So, I mean, that would go a long ways, because if it's a joint petition, that's going to disclose the income of the family.
Okay.
So, I guess my thought on that is to have you file that, provide a copy to Ms. Blaglio, and I could set that issue alone over. It wouldn't be next week; it'd be 2 weeks to address that issue.
Okay, that would be fine. Is the court wanting any other information so that I make sure you have everything you want?
At this point, I think he's asking for a deviation, and you've got a declaration that says he's paying out $6,700 a month in expenses, showing 0 income under his declaration that he filed. And then, so that's what my problem is. I don't have the information in front of me to be able to make an accurate calculation.
Okay, we will get additional information.
Okay. So, let me just double check here. So that would be the 2nd of July. That'd be at 1 o'clock.
Okay.
And so, Mr. Blaglio, what's going to happen? She's going to send you copies of the same document she's going to file. Take a look at it, and then I'll make a decision about what the support should be on the temporary basis, at least based on the motion. All right.
All right. Thank you.
Okay. So we'll come back on the 2nd and address those.
Thank you.
You're welcome. And we've got 2 issues. One is a contempt issue and one is a support issue.
Correct. And Judge, this is my client's motion, Carly Bliss on behalf of Jonathan Hill. Looking first at the contempt, I think it's very clear. This matter has been before the court previously. Ms. Hill was found in contempt for this issue previously, pursuant to the bench order, albeit it's an old bench order from December of 2021. If my client suspected Ms. Hill of being under the influence, he was permitted to test. Ms. Hill then has to comply with the testing requirements. In this instance, in April, she refused to comply with that provision, indicating she didn't have to anymore. I would note that in the file, there is no subsequent order changing or modifying that provision. My client incurred costs. He did provide the cost of the test in the receipt, to your honor. He did prepay $67 for the test. Pursuant to their company policy, they kept $25 of that as non-refundable. So he does have outstanding funds, that he is asking to be reimbursed. So for that purpose, we are asking the court to make a finding of contempt. Again, it's clear, the language is clear. She's to test within 4 hours. She refused to do so, still has not done so. Again, this has been a problem historically. He's made similar requests. She either hasn't done it or she has and has tested positive. So it's not an instance of my client just abusing the privileges of this order or testing, at random. He did have significant concerns regarding her substance use, primarily marijuana, as it has historically been, and Ms. Hill's refusal to comply with the testing provisions, I do believe, is a violation of the court order. So we are asking for a finding of contempt. We're asking for reimbursement for the testing costs and attorney's fees and costs for service in this matter, given her violations. We are asking for some specific language to be included, and this may need to come on a different motion or at the conclusion of the case. But in this case, obviously there's been some confusion as to the validity of the language back in December. And then I don't believe that there's the firm standard language that we typically have that outlines reimbursement if it's dirty, the party paying eats the cost if it's clean, the standard language. So we are asking that those be included in any order moving forward. As it relates to child support has not been addressed in this matter for a substantial period of time. There has been a change of circumstances in the fact that my client is unemployed. Mrs. Is employed and is working, last I had heard. So we are asking for just a standard recalculation of child support in this matter. I do believe it's appropriate. The last child support order was entered, I believe, back in, was it 2019? Give or take. 2021, excuse me. So we're going on 3 years at this point without readdressing child support. My client does have the child 100% in his care. Mom was historically completing reunification counseling with the child. She is permitted under prior orders to have professionally supervised visitation. She has since discontinued that as she indicated she no longer wanted to pay for that service. So at this point, all she's having is reunification counseling. My client is incurring substantial costs to care for this child 100% of the time, and we do need to readdress child support. Those are our requests before the court today. We do believe that they're appropriate, and we do ask the court to grant them today.
Roberts.
So I'll start with the child support issue first. So my client's not disputing that the court can address and adjust the child support. Sorry, I heard somebody and I wasn't sure if it was.
Okay. We're getting some feedback. Let me figure out where that's coming from. Go ahead.
Apologies, Your Honor. So with respect to the child support, my client's not disputing that it's appropriate to address the issue of child support, what my client is disputing is the amount, and what she's asking for is for the court to adjust it in line with her current income and imputing income to Mr. Hill. As noted in her declaration, Mr. Hill, other than his statements in his declaration, has provided no documentation to the court with respect to what he's done to actually find a job. He provides no information about his applications. He doesn't indicate any, other than to tell the court that he's making attempts to find a job. He provides nothing additional. With respect to the issue of in addition, I would note to the court that his motion comes on the heels of essentially final payments on his unemployment. So he's been on unemployment for quite some time, but he doesn't provide any substantial documentation about what he's actually doing to find a job. So we would ask that the court, if the court's going to modify it, we're asking the court to adopt our client's proposed worksheet and impute Mr. Hill to his historical gross income, and also allow my client an opportunity of a step up towards the new amount, since it is a substantial change, and she only nets approximately $3,000 a month. The statements from Ms. Bliss about my client not, exercising her supervised time, Your Honor, she can't afford to do that and hire a professional supervisor, and also afford all the other things with respect to reunification and the other requirements that the court's put on her as far as that is concerned. So it's not a matter of she doesn't want to, it's a matter of finances. And thus far, Mr. Hill's been unwilling to, go back to being doing what they were doing, which is supervised visits with an agreed upon professional supervisor. With respect to the contempt, my client would stand on her declaration. It is her position that there was this idea, and it's clear in the clerk's notes that their reasonable suspicion, and she has literally not had anything other than reunification. So the only time she's seen the child is with a professional in reunification therapy, and that's through Charlotte Rosen's office. So her declaration is very clear that his request for this drug test came essentially upon her finding out that Charlotte Rosen's office and the reunification therapists were recommending increases in that reunification process, and that ironically, that's when this motion got filed. So she would ask the court not find her in contempt, not award fees, and allow things to progress forward on the reunification process. If the court believes there is additional language that needs to be facilitated in order to make orders with respect to this drug testing issue more clear, I think that's more appropriate for Ms. Bliss and I to come to those agreements or to file a motion with the court to address those. But I don't believe that my client willfully, and as she stated in her declaration, she doesn't believe that she willfully violated the court's order. And given the context and scope of what the parenting actually is and has been for since, going on a long time, but the reunification started in approximately December 2023, that she did not willfully violate that order. Thank you.
All right, Ms. Bliss.
And I would just note, at least for purposes of the contempt, the order as it stands doesn't have language in there that says, can't consume alcohol or drugs 8 hours prior to visitation. It simply says that she can't consume alcohol or drugs, period. So to state that just because she is doing reunification counseling and doesn't have visitation with the child, that therefore means that she isn't in violation of the order by consuming alcohol or drugs, I think falls flat. The order is what it is. She failed to comply with the testing requirements as it is ordered. I think she's in violation of that court order and should be found in contempt. My client provides in his reply declaration that the party's 18-year-old son is what led to his suspicion. There is a concern regarding her consumption of drugs and substances, which he observed while in her home. So there was a reasonable suspicion, and my client did exercise his right under that order. Ms. Hill failed to comply with it. Clear as day, it's contempt. As it relates to child support, again, my client has been unemployed since November of 2023. I don't think that there's a requirement that he provide his proof of applying for jobs and the like. If the court would like to see it, he'd be more than happy to provide it. He provides in his declaration. He's tried and tried and tried and simply has not been able to. The court could impute him at a higher wage, but I'm asking the court at this point to impute him at the wage that we've included, which is what he's receiving from unemployment, as that is what he's been receiving for the last 7 months. Obviously, this matter can be readdressed once he gets a job, but at this point, it is what it is. He has this child in his care 100% of the time. He needs support to do so. In looking at Mrs. Income in the worksheets provided by her counsel, her gross income's higher than our gross income. I would defer to the court on what we do with that. I would just note, looking specifically to the retirement contributions, her paychecks reflect about $83 being put towards her 403B. Her calculations in the child support showed $243 a month. That was the only inconsistency I saw, but child support being addressed is appropriate in this matter, and we are asking the court to adopt our worksheets as we presented them.
I even in this case, it looked like, and when I looked at your response, it indicated the state had filed a child support. They didn't have one attached, according to your response. Did you file one?
Your Honor, that may have been a typo. Not file a set of worksheets. The state's interest is just regarding medical expenses for this case. So if there's a change to the child support order, we would just request that it reflect the child is on state medical with Kelsey Hill, and that there's a proportional share for any uninsured medical and daycare costs.
Okay. All right, I thought maybe there was something that got missed because your response specifically said there was a worksheet.
I apologize, Your Honor. We have two different ones. One says we do file them and one says we don't. We just inadvertently filed the one that says we did. I apologize.
Okay, that's fine. Well, when I looked at the documentation that was provided, he got unemployment for 6 April, something like that. His prior income, which is apparently what he's capable of, would probably be the appropriate amount to impute to for purposes of calculation. So when I looked at that worksheet that looks like it was filed here May 28th by Jamie Hill. And I don't know where that, I don't know what the support number calculates out of that. I don't think I saw.
Your Honor, I have that worksheet. Would you like me to tell you what line 17 is?
Looks like it was 827. Am I looking at the right one?
Well, for her, it'd be 471 based on what I'm looking at. Is that accurate?
Yes, Your Honor.
Yes, sir.
That line 17 is 471.54.
Okay. What's the current support right now?
I have to look. Looks like it was 400 when both kids were there, so now I'm assuming it's 200 now that Baker has aged out.
That's correct.
Okay, that would make sense. I think I do remember seeing that. Okay, so your percentage would come up of the worksheet, which looks like it's where did that go? I was just looking at it. 36 and 63 for the percentage basis, and then would be the 471 that would be an increase for single child of more than 30%. So that should go into effect at half of that increase. I'll let someone else do the math on that. And that would be, and that should start 6/1 going forward. So 6 months at half the increase, and then after that. The contempt order it's pretty clear when I look at the order that was entered by the commissioner, is that it's somewhat unclear, and it's not necessarily clarified by the notes. It does not require a specific, and the order is what governs, even though there may have been some other statements made. If the parties had an issue with the order that was entered, that could have been brought back for clarification or correction, and that apparently wasn't done. So the order that is entered is the order that I'm working off of, and that's the one from 12/9, which requires her to take a test if she's notified. It doesn't have any specific, it's not tied to any visits or anything else. It's just simply what it doesn't have, though, is it doesn't have any reimbursement provision, which is interesting. It has a remedy of coming back to court and visitation ceasing, which is not what we're here about from the sounds of it. So, so that's not a request being made today based on what I read, correct?
That is correct, Judge.
Okay. So at this juncture, we probably, this order needs to be cleaned up if it's going to continue. It needs to be, it shouldn't have an automatic cease of visits. It needs to be brought back before the court. For that were to happen, there should be this, the reimbursement provision should be within the order. Because it's just, I mean, it's not, it doesn't accurately carry over what was done at the hearing, and then it's not complete. So I'd like to see a modified, an adjusted version of that order going forward that has that stuff more specific. I think the fact she decided she wasn't going to do it is just, I mean, that is contempt. She had an ability to do it. There's no indication she didn't have an ability to do it. He did expend costs, and I think that's a reasonable reimbursing those costs. Just a second here. And I don't have those right in front of me what that was. I think Ms. Bliss had put that into the motion.
I believe it was 67 is what he paid, and he got all but 25 back. So I think it's just $25, but let me confirm.
Let me just here.
Yeah, I had in my contempt hearing order just $25 for the reimbursement.
And it's not a contempt of the parenting plan, it's contempt of a specific order. So there's no specific statutory penalty, which would be for like a parenting plan violation or something. So what I will do is I'll order the reimbursement of the, if it was 25 or whatever that was, that for the reimbursement for the test. And I will order the fees to be done. I don't know. There's an order here. Ms. Roberts, did you get a copy of the proposed order?
I'm looking at it right now, Your Honor. I did, but
I would think, given Your Honor's, not to interrupt Ms. Roberts, I think given Your Honor's ruling of essentially suggesting that we put the standard UA provisions in a different order, I would just ask that you just strike the language included in 13. But I think otherwise it's reflecting what Your Honor's ruling.
Yeah, I will strike 13.
my only request would be that the court extend the time in which the fees are due, given the increase in child support and the amount of money that my client actually makes. I would ask for 60 days to pay the fees, but the reimbursement on the testing, I would agree that the 30 days would be fine. So that's the only revision I'm requesting.
I think given all of the changes, that's probably not unreasonable. So order the fees within 60. The refund on the test in 30. And crossed out paragraph 13. I've signed that order.
And Ms. Roberts, do you think we need a presentation for the child support, or no? Okay, we could probably submit that.
I think we can do that.
So really any Friday, next Friday would be excluded because I'm not here next Friday, but generally any Friday at 8:45 if you can't come to an agreement on that, or you can do it on this docket as well.
Okay, very good. Thank you, Judge.
All right, you are welcome. I believe that is everything on the docket, so we will adjourn.